Hello, motherfuckers! Welcome to this week's episode of Law and Ordinary People. As always, we're here to tell you your legal rights and try and help keep you out of trouble for another bit of time. As always, please note that while we do try to give you our best legal advice, the law changes all the time, and sometimes the law is even an ass. But we're here to give you general legal advice. If you need specific legal advice, you should contact your solicitor, because solicitors are cool. Okay. Before we get started, remember as well, feel free to tweet us any more questions you have or to email us at breed@fecttv.com. So kicking off the first question, we've got something in from Nikki, who says, "Hi B, I heard about the builders who found the ancient coins in Carrick-on-Shore a few days ago and handed them into the National History Museum or somewhere. Is it true that if you find old stuff like that, you have to give them to the state? Because if you find it and there is no other owner, surely it would be yours." Nikki. Well, Nikki, therein lies a good question. The truth is, coins and sort of old stuff like chalices and brooches traditionally and things would be considered archaeological objects, and technically, legally, they become the property of the state as soon as they're found. Whether it was on your own property or someone's property, or you found it or you spent money in doing it, unfortunately, you don't really own your own property 100%. Much knows you can own your own property if there's something underneath it or, airspace over it. The state has what's called a low deal title, and they will always claim these things. And that's why CPOs and things work. So you actually don't get to claim 100% of everything that's on your property, unfair and all as it may be. However, while the finders are obliged to give things to the National History Museum or their local museum, who will point you in the direction of the National History Museum or take it off you, you will get a finder's fee. And this was very topical back when the Derry-na-Flan chalice was found, because when they found that, the Webbs, who were the two guys who found it with their metal detector, went to court because the National History Museum took their Derry-na-Flan hoard, which they found in Clonmel, and they said, "We're going to give you a finder's fee." But the guys were like, whoa, this is worth like €5 million. But the National History Museum, or the state, were like, yeah, we'll probably give you 50,000 or something. But that just wasn't enough for them. So it ended up going to the Supreme Court. There was 7 years of litigation. It was called Webb versus Ireland. You should Google it if you're interested. It was crazy. But in the end of the day, they found out that, yes, the state has the right to take these things as national treasure. So then a year later, they updated the laws and the statute books to make it really, really clear that no matter what you find, it belongs to the state if it's archaeological objects. So that's where it is at the moment. Oh, interestingly as well, if you decide to go out and search with a metal detector or excavate ruins of an old site that was considered archaeological, that will require a license. So you can't just go doing it. So yes, that's why that happened. So the builders, they'll probably get a finder's fee. That's about it. Okay, the next question comes in from Emma. So Emma says, "I have a law show question." Great. "I moved into a house about 9 months ago, but the landlord keeps calling around unexpected and lets herself in. One day, about a week ago, she must have come in when we were all in college, because that evening I got an email saying that my room was extremely messy and I have a week to leave. She also said she would be retaining my deposit to pay a cleaner to clean my room. Now, my room wasn't dirty, there were just clothes everywhere. And if I'd known someone was coming over, I'd have tidied it. Do I have the right to get my deposit back?" Emma. Well, another really good question. I'm so glad someone asked this, because nobody knows their tenants' law's rights. As a tenant, you have rights, but your landlord also has rights. Fortunately for people like us, the tenant has greater rights. That's worth knowing. And if you're ever in any doubt, ring this thing called the PRTB, the Private Residential Tenancy Board. They'll tell you everything. Firstly, I should point out to you that one right as a tenant, if you're paying your rent and keeping things up to date, your landlord has no right to enter your property, because technically you're the person with the right to that property. If the landlord comes over and disturbs your sole and peaceful exclusive possession of the property, which you have by the fact that you've entered into a tenancy, then technically your landlord is trespassing, and you can ask that person not to come in. You have the right to do that unless you're breaching one of your obligations to your landlord, like you've done something stupid with the house or something, or you've not paid your rent. Interestingly enough, trespass is a tort that's actionable per se. So technically, while you'd never get anywhere, you could really be suing your landlord for this. It's just nice to know. In regard to the deposit, yes, you can go to the PRTB and demand it back. Your landlord cannot keep your deposit for no reason at all. The PRTB, the Private Residential Tenancy Board, they do this all the time. It's really, really cheap, like 20-something euro to apply to the PRTB, and you can get your 20-something euro back at the end of the day if they do decide that the landlord was wrong to keep your deposit. The PRTB, it's not like a judge and jury. You literally go into this meeting, your landlord will be there as well. You've got an adjudicator there, or like a mediator. Well, really it's an adjudicator, but it's like a mediator. It's a guy who's just like, so lads, go on, tell me what happened. And you basically tell the story, and he decides who wins or loses and who pays who the money. And that's legally binding. And it can be appealed, and you do it again, but same story, legally binding. So the landlord can't keep your deposit for things like normal wear and tear, because that's expected will happen during a tenancy. They can only keep it if you've done something stupid like breaking windows. So it's really, really reasonable. Also, interestingly, you haven't asked me about it, but you should know, once you're in a property for over 6 months, a landlord can't just ask you to leave, because you become what's known as a Part 4 tenant. So 6 months, you suddenly are Part 4 tenant. It becomes extremely difficult for a landlord to get you out at all. Even when the contract finishes, when your lease is over, you can still demand it to be renewed. It's insane rights that tenants have, but this has been happening since 2007 and nobody knows about it. So you should know, 6 months, you're sweet. So it's very difficult for your landlord to get you out. So don't be going anywhere. And if they do, go to the PRTB and ask for compensation for that. The next question comes in from Ian. So Ian says, "Hi Breed." No fada over my eye, but we'll get over it. "I got a letter from my old boss recently saying the following. Is this serious or does it mean anything? I think they're just trying to scare me, but I don't know into what." So the letter goes, "Dear person, we act for company who you formerly worked with. Your contract of employment contained certain restrictions on the use of confidential information which came into your possession while employed. Such information remains the property of the company. This information would include client lists and contracts, pricing information, and information relating to specific technical requirements. It has come to our client's attention that you are using this information for your own benefit now. This is completely unacceptable and in breach of the terms of your employment contract. We therefore hereby call upon you to immediately cease and desist from this course of action and to furnish your undertaking not to engage in any such activity which may have detrimental effect on our client's business. Should you fail to furnish such undertaking within 5 days of the date hereof, our client will take all appropriate steps to protect its rights, including seeking injunctive relief, and will seek all attendant legal costs incurred." There's a heap of legalese in that question, or in that letter, so I'm not actually surprised you didn't really know what the hell they were talking about. If you rang them up on the phone, they would tell you in plain English what they meant, because in fairness, no solicitor comes out of the womb talking like that. Everyone knows that's nonsense. But what they basically mean, and what I bet you never noticed, is your contract of employment probably has this little thing in it saying that you won't compete with your employer for like X amount of years after you left them. So it's called a non-compete clause or a restrictive covenant. So it probably says something like, if you leave our employment or from the date hereof, you can't compete with us for 5 years or something. It has, however, to be restricted by time and geographical scope. So it can't be like worldwide, it'll have to be like Ireland. And it usually can't be as long as 5 years. Generally 1 year would cover you. So firstly, you need to go back to your contract of employment and see what's in there about those things. Anything that says restrictive covenant or non-compete clause or something, you'll see it. But usually when people get employment contracts, they're so happy with the fact they've got a bloody job, they don't actually read the contract well enough. So I think from that, they're saying that you're poaching clients or doing something that you shouldn't be doing. So you're going to need to check that. Check exactly what you signed up to. In relation to the injunction, people always threaten things like that. I wouldn't take it too seriously. At the same time, you've got to take it sort of seriously. So I'd reply to them and just say, yeah, I'm not doing that if you're not doing it. And that'll be enough for them. An undertaking basically means promise them. And yeah, you need to reply. The costs they're on about the injunction is if you really do nothing and if you keep poaching their clients, they are going to go to court and say, stop this. And they will look for their costs, which will actually be massive if they're getting an injunction. So you don't really want it to get there. But I swear to God, they actually have no intention of doing that. They just want to talk to you about this. They are sort of trying to scare you a little bit with that letter. Also, I don't really know would they get an injunction. Injunctions are given out based on the court wondering, is there a balance of convenience? Is there a serious question to be tried? and damages as an adequate remedy. In this case, damages would probably be an adequate remedy, but take it seriously, get back onto the solicitors, ring them up, say what are you saying. It's really common sense. Just ask them to speak to you in plain English if you don't know what they're on about. Our next question comes in from Mary, who says, "Hi, law and ordinary people. I have a question. I'm a nurse and I was wondering, is it necessary to make a will with a solicitor? Sometimes you hear someone has had a bad turn and it may be after office hours. What can we do then?" Mary. That's a really good question, Mary. And people hate paying solicitors, so it comes up the whole time. In fairness, wills aren't that expensive to do. So ring a solicitor up in advance and say, this is what I want to do, if you are doing a will. But anyway, you're talking about a situation where you can't get a solicitor because it's a last minute thing. I think your biggest problem there is making sure that the person is of sound disposing mind, because the requirements for a will are that it be in writing, which isn't too difficult. It can be in any kind of paper. It could be on the back of a tato bag, as long as it's in writing. That the person making it is over 18 or married, because I don't know, that seems to make you more sensible or something. That the person is of sound disposing mind. So that doesn't necessarily mean sound mind. They can still think there's rabbits flying around the ceiling, as long as they know what they're doing with their money and they realise that if they give it to such a person, that's it. So sound disposing mind is a little different from sound mind, and that's another reason why having a solicitor is a good idea there, because we get it. Sign with your mark or your signature or an acknowledgement of someone else signing on your behalf. So that's another thing that solicitors will have practiced saying that, and you could technically get wrong, but you might be able to get over it. There needs to be 2 witnesses in the testator's. The testator is the person making the will. 2 witnesses in their presence as they sign it. Those people cannot be gaining from the will. So if you're doing it, nurses or someone might be a good idea. They must see the testator sign it, and they almost sign at the bottom of the will. So there can't be another bit, oh, I forgot to give away my car, put in underneath it. You need to sign underneath everything. So technically it's doable, but it's really, really dangerous, because you say things like in a will, if you said, I give €1,000 to Mary and Jane, does that mean €1,000 each or €1,000 between them? Solicitors think of these things because they've seen it a million times and they've spent years being educated about it. So it's always a much better idea to use a solicitor for the sake of the €50 or €100, whatever it costs. Definitely worth it. Technically as well, you can give away something in your lifetime. Something that's gifted in your life is a gift, and anything that's gifted before the will comes into play is gone, so it doesn't come into count. There's a lot of other things. You really, if it comes down to it, try and get a solicitor out of hours. Ask someone, because I swear to God it's worth it. But good luck, and I hope you're never in this position. So that's all we have time for today on Law and Ordinary People. As always, if you have any questions, email them to me at breetheffernan@fecttv.com or tweet or Facebook FecTV. Thanks for joining us.